Hey everyone, and welcome to another deep dive. This time we're tackling a topic that sounds like it's straight out of a law school exam. Exempting circumstances in the Philippine Revised Penal Code.
Specifically Article 12.
Right, Article 12. But don't worry, you don't need to be a legal eagle to follow along. We're going to bring it down in a way that's hopefully easy to understand.
Hopefully.
Well, I'm feeling optimistic. So, what we're really talking about are those rare situations where someone commits a crime.
A crime.
Yes,
Yeah.
like actually breaks the law. But legally speaking, they might not be considered guilty. How is that even possible?
It's a fascinating area of the law, really. It all boils down to the concept of exempting circumstances. Basically, it means that while the act itself is considered a crime, the person who committed it might not be held criminally responsible due to certain factors.
Okay, so it's not that they're off the hook completely, but the law recognizes that their situation, for lack of a better term, complicates things.
Exactly. It's about recognizing that there's a difference between an act and the intent behind it. And these exempting circumstances, they help us understand that distinction.
Okay, that makes sense. So it's not about erasing the act itself, but understanding the nuances of why it happened and whether the person can truly be held accountable. So let's dive into those circumstances. Where do we even begin?
Well, I think one of the most intriguing ones, and one that often pops up in, movies and TV shows, is the concept of imbecility or insanity.
Ah, yes. The
Ah,
classic pleading insanity defense. But how does that actually play out in real life? It's not as simple as it seems in the movies, right?
Not quite. It's definitely more nuanced. First of all, you have to understand that the law actually distinguishes between imbecility and insanity. Imbecility refers to a more permanent state of mental incapacity, whereas insanity can be temporary. But the key thing for both is proving that this state of mind was present at the time of the crime.
So it's not just about having a diagnosis on paper, but proving that it directly impacted their actions during the crime.
Precisely. Let's say, for example, you have someone who has been diagnosed with schizophrenia, and they are known to experience episodes of violence. If they commit a crime, the court wouldn't automatically assume they were insane at the time. They would look for evidence. Were they exhibiting any signs of hallucinations, delusions? Was there anything about their behavior that would indicate their mental state at that specific time?
That makes sense. It has to be directly related to their actions during the crime, not just a general diagnosis. But you mentioned temporary insanity. What about other situations? Like, what if someone commits a crime during a really severe medical episode?
Absolutely. That's where things get even more complex. Let's say someone has a sudden and severe case of, say, malaria, and during a period of intense fever and delirium, they commit a crime. The court would have to consider whether their mental state during that specific episode met the criteria for temporary insanity.
Wow, that is a really complicated situation. And it highlights how the law really tries to take those specific circumstances into account. It's not just about the act itself, but the context surrounding it.
Exactly. And that actually leads us to another fascinating exempting circumstance: the age of criminal responsibility.
So there's literally a point where someone is considered too young to be held accountable for a crime.
Yes. In the Philippines, anyone under the age of 15 is considered entirely irresponsible for their actions, no matter the crime.
Okay, that makes sense. But what happens if they're older than 15, but still quite young, like 16 or 17?
Right, so between the ages of 15 and 18, it gets a bit more complicated. It's not as clear-cut. This is where the concept of discernment comes into play.
Discernment, what does that even mean in this context?
Essentially, it refers to the ability to understand the weight of your actions, the potential consequences, the difference between right and wrong.
So it's not just about knowing right from wrong, but truly understanding the impact of your choices.
Right. Let's say you have a 16-year-old who steals something. If they try to hide it or lie about it, that suggests an awareness of wrongdoing.
So they understand that what they did was wrong.
Exactly. But if they seem genuinely unaware that they did something wrong, well, that paints a very different picture of their understanding of the situation, right?
It becomes less about the act itself and more about their mental state, their awareness.
Exactly. And this concept of discernment, it played a crucial role in determining criminal liability for those in that 15 to 18 age range.
That's a lot to think about. It really emphasizes that intent and understanding are so crucial in the eyes of the law, especially when it comes to young people. But let's shift gears a bit and talk about something that I think a lot of people might encounter in their everyday lives. Accidents.
Accidents, yes. They're a great example of how exempting circumstances can pop up, even in seemingly ordinary situations.
Okay, so let's use a really common example. Car accidents. Let's say there's a minor fender bender. Is it always automatically someone's fault if you bump into another car?
That's a perfect example. It illustrates how the law differentiates between an accident and, say, negligence.
Because those aren't the same thing.
Not at all. The Revised Penal Code, when it talks about causing injury, it uses this phrase, by mere accident, without fault or intention. So for something to be considered a true accident, several elements need to be present.
Okay, I'm listening.
First, you were doing something lawful, meaning you weren't breaking any rules at the time.
Right, makes sense.
Second, you were acting with due care. So, no speeding, no texting while driving, none of that.
So basically, being a responsible driver.
Exactly. And lastly, the outcome, the accident itself, was unintentional and, importantly, unforeseen.
So if you're driving safely, following all the rules, and then, I don't know, a sudden hailstorm causes you to slide on the road and bump into the car in front of you, that could be considered a true accident.
That's a great example because it highlights the importance of those elements. You were driving responsibly, the hailstorm was an unforeseen circumstance. In the eyes of the law, that's a true accident.
But let's say in that same scenario, you were texting while driving, and that's where you didn't react in time to the hailstorm. That changes things, right?
Absolutely, because now the element of foreseeability comes into play. You were not only breaking the law by texting while driving, but you also should have foreseen that it could lead to dangerous situations, especially in unpredictable weather conditions.
So in that case, it's no longer a true accident, but negligence. You're responsible because you should have known better.
Precisely. That line between accident and negligence often hinges on that element of foreseeability. Did the person act with the appropriate level of care given the circumstances?
This is fascinating. You shows that even in everyday situations, the law has to grapple with these fine distinctions, to determine who is ultimately responsible. But what about situations that are far more extreme? Like what if someone is forced to commit a crime?
Now we're getting into some really interesting territory. That's where we start talking about concepts like irresistible force and uncontrollable fear.
Okay, those sound intense. What's the difference?
Yeah. So picture this. Someone physically forces you to commit a crime. Like they're literally controlling your body to carry out the act. That's what the law refers to as irresistible force. Now imagine a situation where you're being threatened into committing a crime. That's where uncontrollable fear comes in.
Okay, so the difference is physical force versus a threat of harm. But in both cases, it's about someone else compelling you to commit a crime.
Yes, but the key in both situations is that the force, whether it's physical or psychological, has to be so extreme that it completely overrides your free will.
Wow, so we're not just talking about like everyday pressure or coercion. It has to be a situation where anyone would feel like they had no other choice.
Exactly. It has to be that extreme. For instance, historically, there have been cases of individuals claiming they were forced to join, say, rebel groups like the Katipunan under threat of death.
So in those cases, the law has to weigh the lesser evil, right? Joining a rebellion versus the very real threat of being killed.
Exactly. But even in those situations, the law often requires that the threat be imminent. Like a vague threat of future harm, that's usually not enough to qualify as uncontrollable fear. There has to be that immediacy, that sense of, I have to do this now to avoid immediate harm.
That makes sense. There has to be that immediate pressure for it to hold up in court.
Yeah.
So we've talked about situations where someone commits a crime, under duress. But what about those instances where someone doesn't do something that they're legally required to do? Is that ever justified in the eyes of the law?
That's a great question. And it brings us to another exempting circumstance, lawful or insuperable cause for inaction. So this is where someone fails to fulfill a legal duty, but for a really valid and compelling reason.
Okay, so this is like the I couldn't do it and here's why clause. But what kind of reasons would actually fly in court?
Well, let's start with lawful cause. Imagine a priest who hears a confession about a crime. Because of the sanctity of the confessional, they are legally bound to secrecy. They cannot reveal what they've heard, even if it's about a serious crime.
Right, they have that confidentiality agreement.
Exactly. So in that case, their legal obligation to maintain confidentiality prevents them from fulfilling their civic duty to report a crime.
That's a classic example. So what about insuperable cause? What kind of situations would fall under that?
Think of insuperable cause as a truly impossible situation. Imagine a mother who has just given birth, but she's utterly incapacitated, maybe due to severe complications. She's physically incapable of moving or caring for her newborn. Typically, the newborn needs immediate attention.
Oh no, that's heartbreaking.
Yeah.
But I see how the law might apply in that extreme circumstance. It's not that she's deliberately neglecting her child, she's physically incapable of doing anything.
Exactly. And it's important to remember, in these cases, it's not about excusing wrongdoing. It's about recognizing that the intent to break the law was simply absent. These circumstances, they force us to confront these gray areas of responsibility, where a clear-cut judgment, it becomes much more complex.
This has been so eye-opening. It's amazing how much nuance and complexity exists within these laws that we often take for granted. But I have a feeling this is just the tip of the iceberg, right? There's more to this story.
Oh, absolutely. We've only scratched the surface here. Article 12, this is just the beginning.
There are even more situations where the lines of criminal responsibility get blurred. I can't wait to hear more. You're right. We haven't even touched on absolutory causes yet.
And those can be even more mind-bending than exempting circumstances, that's for sure.
Okay, now you've got me curious. What exactly is an absolutory cause? How is it different from what we've been talking about?
So, with exempting circumstances, remember, we're saying a crime happened, but the person isn't held responsible. Absolutory causes are a bit different. It's more like the law is saying, yeah, that's technically a crime, but we're not going to punish it.
Seriously, when would that ever be the case?
Well, funny enough, we already saw a couple of examples back in Article 12.
I'm not sure I remember. Refresh my memory, will you?
Remember when we were talking about the fender bender? Even if there's no criminal liability because it was a true accident, there might still be civil liability. Like, you could still have to pay for damages.
Right. No jail time, but your wallet might still feel it.
Exactly. But with lawful or insuperable cause for inaction, there's no penalty at all.
So like with the priest in the confession or the mother who couldn't physically care for her baby, they're completely off the hook.
That's right. The law recognizes that holding them liable wouldn't really be just. But let's move beyond Article 12 for a bit. Absolutory causes, they pop up in other parts of the Penal Code, too. Take Article 20, for example.
New article, new adventure. What's in Article 20?
This one deals with accessories to a crime. You know, the people who help the main perpetrator, even if they aren't the ones actually committing the crime.
The getaway driver, the person who helps hide the stolen goods, that kind of thing.
Exactly. Usually, accessories face some kind of penalty, too, depending on how involved they were. But Article 20, it throws a bit of a curveball.
Oh, how so?
Well, it basically says, hold on a minute, if the accessory happens to be related to the criminal in a specific way.
Wait, are you saying family members get a free pass if they help someone commit a crime?
Not a free pass to commit crimes, no. But an exemption from being punished as an accessory, yes. It applies to spouses, parents, grandparents, children, grandchildren, even siblings.
Hold on. Let me get this straight. So hypothetically, if my brother robs a bank and I help him hide the money, I'm in the clear legally just because he's my brother.
That's the gist of it. There's a catch, though. This exemption, it doesn't apply if you benefited from the crime. So if you helped your brother to get a cut of the money, then no, you're not off the hook.
Okay, that makes sense. Can't use family ties as an excuse if you were in on it from the beginning. But if you were acting out of some misguided sense of loyalty, you could be exempt. That's wild.
It is interesting, isn't it? The law and family ties always makes you think. Speaking of which, there's another absolutory cause I think you'll find pretty intriguing. Article 24(7).
Article 24(7). Okay, you're really drawing this out. What is it?
This one deals with a very specific situation. Let's say a married person catches their spouse in the act of being unfaithful, and things get, shall we say, a little out of hand.
Wait, are we talking about what I think we're talking about? The crime of passion defense?
Some people call it the infidelity rage clause. It basically says that if you harm or even kill your spouse and their paramour in a moment of intense anger right after catching them, well, the penalties are reduced. Let's just say that.
Wow. Okay. So the law acknowledges that infidelity, discovering that, can be a really intense experience, and sometimes people react badly.
Yes. It recognizes that these situations can lead to, let's call it, a temporary loss of reason. Not that it justifies violence, of course, but it's about understanding the context. So in these cases, you might face a lighter penalty, and in some cases, you might even be completely exempt from punishment.
That is a lot to process. So we've got insane defenses, family loyalty loopholes, now crimes of passion. Where do we even go from here?
Oh, we've only just begun. There's a lot more to uncover in the world of absolutory causes, believe me. Article 332, for example. That one's all about crimes against property.
Okay, like theft.
Theft, swindling, malicious mischief, you name it. But the interesting part here is who you're stealing from, or really, who the law is choosing to protect.
Oh, I'm sure I follow.
All right, imagine this. You catch someone red-handed stealing something from you. What do?
Call the police, obviously.
Of course. But what if that someone is your spouse or your child, your sibling?
Wait, are you serious? The law protects family members who steal from each other.
Article 332 basically says that certain relatives, they can't be charged with these crimes. Spouses, parents, children, siblings, as long as they live together in the case of siblings.
I can't believe it. So if my sister borrows some money from my wallet without asking, I can't do anything about it.
Well, you can't press charges for theft, that's true. You could still pursue other avenues, like civil action, if you wanted to recover the money. But the criminal penalties, they wouldn't apply.
So it's like the law is trying to protect families, even if someone does something wrong.
You could say that. It's a delicate balance, for sure. Acknowledging that stealing is wrong, but also trying to preserve family harmony. It's definitely a fascinating area of the law.
Fascinating, sure, but I don't know if comforting is the right word. So what else? What other legal surprises do you have up your sleeve?
Oh, we've got plenty more where those came from. We're just getting started with the wild world of absolutory causes.
All right, listeners. I don't know about you, but I need a minute to process all of this. Join us for the third and final part of this deep dive, where we'll explore even more of these mind-boggling legal exceptions. You won't want to miss it. We're back, and I'm ready for more legal adventures. What other absolutory causes are out there?
Well, since we like to keep things interesting, I've saved one of the most, shall we say, thought-provoking ones for last. Article 344 of the Revised Penal Code, specifically paragraph 4.
Article 344, paragraph 4. Okay, that sounds serious. What's it all about?
This one deals with what happens after a crime,
Yeah.
specifically crimes against chastity, things like seduction, abduction, acts of lasciviousness, not even rape.
Those are some heavy stuff. What could possibly happen afterward that would lead to an absolutory cause?
You ready for this? What if I told you that marrying the victim could actually make the criminal charges go away?
Wait, seriously. The law in the Philippines says that getting married can just erase those kinds of crimes.
In a nutshell, yes. Article 344, paragraph 4, that's exactly what it says. If the perpetrator marries the victim, the case can be dismissed, even if there's already been a conviction.
I don't even know what to say to that. Is that even legal anymore?
It's definitely a complicated issue. It comes from, well, older ways of thinking about these things, and it's been a huge source of debate and controversy. But yes, it's still part of the Revised Penal Code, although there have been a lot of attempts to get rid of it.
I can see why. It's like it's putting marriage above, the victim's experience, their trauma.
That's a big part of the criticism, definitely. It ignores the victim's right to decide what justice means for them.
It's pretty mind-blowing how laws can reflect, the values of the time they were written in, even if those values seem outdated now.
Absolutely. And it shows how law is always evolving, changing as our understanding of things like justice and human rights changes, too.
So, while Article 344, paragraph 4 might be a pretty shocking example of an absolutory cause, it also reminds us that the law isn't perfect, is it? It's a work in progress.
It certainly is. And by talking about these things, questioning them, that's how we make the law better for everyone.
Well said. Well, listeners, I have to say, my mind is officially blown after all of that. We've gone from insane defenses to family loyalty loopholes to crimes of passion, and even marriage as a get-out-of-jail-free card, it seems. It's clear, criminal responsibility is a lot more complex than it appears on the surface.
It's been a pleasure exploring these complexities with you. Hopefully our listeners are feeling a little more informed, a little more aware of how nuanced the law can be.
And maybe a little more curious about the law, too. It might seem intimidating, but understanding it, even the strange parts, can help us all navigate the world a little better. So until next time, keep asking those questions, keep those minds sharp, because even in the world of law, the truth can be a lot stranger and a lot more interesting than fiction.